Am I eligible for paid sick leave? You wake up sick, your child has a fever, or maybe you need time off for a doctor's visit. The question is simple but stressful. Will you still get paid if you stay home? In the United States, the answer isn't the same for everyone. Some workers are covered by state or city laws that guarantee paid sick time, while others rely only on their employer's policy. At the federal level, protections are more limited, and many people are surprised to learn what is and isn't guaranteed. In this video, we'll go step by step through the laws that matter: the federal baseline, special rules for federal contractors, state and local laws that expand rights, and the practical steps you can take to use your sick time. Let's start with what the law actually says at the national level. Part 1, the federal baseline, what U.S. law guarantees and what it doesn't. Let's start with the federal floor. There is no general federal law that requires private employers to provide paid sick leave to all workers. That's the baseline in the United States today. The U.S. Department of Labor states plainly that federal law does not require paid sick leave. There are two important federal carve-outs you should know about. 1. Family and Medical Leave Act, FMLA. FMLA gives eligible employees up to 12 weeks of job-protected, unpaid leave for serious health conditions, bonding with a new child, or caring for certain family members. While it's unpaid, your employer must continue your group health insurance as if you were working. To qualify, your employer usually needs 50-plus employees. You must have worked there long enough, generally 12 months, 1,250 hours, and the reason must meet the law's standards. FMLA protects your job, but it does not guarantee pay. Some employers let you use paid time off to cover some or all of your FMLA leave. 2. Federal contractors. If you work on or in connection with covered federal government contracts, a different rule applies. Under Executive Order 13,706 and the U.S. Department of Labor's final rule at 29 CFR Part 13, covered contractors must provide up to 56 hours, 7 days, of paid sick leave per year that can be used for your own illness, family care, or certain safety-related needs. That's a true paid sick leave right, but it's limited to the federal contracting world. If you're unsure whether your job or employer is tied to a covered contract, construction, service contracts, certain concessions or property, services for federal property, ask HR for the contract type or check onboarding materials. So at the federal level, here's the big picture. FMLA can protect your job during serious health or family needs, unpaid, and federal contractor workers may get paid sick time. Everyone else, your rights usually depend on state or local law and your employer's policy. In union workplaces, your collective bargaining agreement might also include paid sick days. Read that section closely. Bottom line, federal law is a safety net, not a paycheck, unless you're on a covered federal contract. To know if you're actually eligible for paid sick leave, you need to look next at state and city rules, and that's where a lot of workers win coverage. Part 2. State and city mandates, where paid sick time is guaranteed. Dozens of jurisdictions require employers to provide paid sick time. Each law sets its own rules on who's covered, how sick time accrues, annual caps, waiting periods, and carryover. Here are clear examples, so you can compare. California, as of January 1, 2024, most California employers must provide at least 5 days, 40 hours, of paid sick leave per year. Accrual and front-loading options exist. Local ordinances, e.g. Los Angeles, San Francisco, may go beyond the state minimums. New York State, employers with 100-plus employees must provide up to 56 hours. Those with 5 to 99 employees must provide up to 40 hours of paid sick leave per calendar year. Smaller employers must still provide leave, paid or unpaid, based on the statute. New Jersey, Public and private employers must provide up to 40 hours per year, with accrual at 1 hour per 30 hours worked. Oregon, employees accrue 1 hour per 30 hours, up to 40 hours yearly. Paid versus unpaid depends on employer size. Paid if the employer has 10 plus employees, or 6 plus within Portland city limits. Yes. Washington State, accrual is 1 hour per 40 hours worked. Unused time carries over up to 40 hours to the next year. No cap on accrual, though carryover minimums apply. Colorado, HFWBA, statewide paid sick leave, with 48 hours of regular sick time annually. Separate public health emergency provisions applied during declared emergencies. New Mexico, Healthy Workplaces Act, accrual at 1 hour per 30 hours worked, usage capped at 64 hours per year, with carryover up to 64 hours. Applies to all private employers regardless of size. Minnesota, ESST, effective January 1, 2024, employees earn 1 hour per 30 hours worked, up to 48 hours annually. Local ordinances, Minneapolis, St. Paul, Bloomington, can be more generous. Employers must follow the rule. Most favorable to employees. Illinois, PLA-AWA, effective January 1, 2024. Workers earn up to 40 hours of paid leave for any reason at 1 hour per 40 hours worked. Employers can front load. This is broader than sick time, usable for anything. Chicago adds an ordinance with 40 hours paid sick plus 40 hours paid leave annually. District of Columbia, paid sick time depends on employer size, up to 7 days for large employers, with specific accrual formulas. Many other states and cities have similar laws. The rules vary, but you'll often see accrual, e.g. 1 hour per 30 to 40 hours worked, annual caps, 40 to 64 hours, carryover, and protected reasons, your illness, a family member's care, preventive care, or safe time for domestic violence-related needs. Always check both state law and any local ordinance where you work. Local rules often add to state rights. Part 3. Eligibility nuts and bolts. Accrual, waiting periods, carryover, and using the time. To figure out whether you are eligible and how much you get, run this checklist. 1. Where do you physically work? Sick leave laws generally apply where the work is performed. If your city has a paid sick time ordinance and you work enough hours in that city, you're likely covered there, even if your employer is based elsewhere. Example, Chicago covers employees who work 80 plus hours in a 120-day period within city limits. 2. Accrual versus front-loading. Most laws let employers choose between letting time accrue, e.g. 1 hour per 30 to 40 hours worked, or front-loading a lump sum at the start of the year. You'll see this structure in many states, Illinois, 1 per 40, up to 40, and Oregon, 1 per 30, up to 30. 40 are good illustrations. 3 waiting periods. Some places allow immediate use, others allow accrual immediately, but require a short wait before first use, e.g. Oregon allows use after 90 days. Always check your statute or city FAQ for the initial waiting period rule. 4. How much can you use each year? Caps vary. California guarantees at least 5 days 40 hours. New York sets 40 or 56 hours based on employer size. Washington requires accrual at 140 with 40-hour carryover. New Mexico caps annual usage at 64 hours with carryover up to 64. Your employer can always be more generous than the law's minimums. 5. Carryover and bank rules. Many laws require carryover of unused time, often up to 40 to 64 hours, even if the employer front-loads the next year. Watch for differences. Washington's rules require carryover of less than or equal to 40 hours, while New Mexico allows carryover up to 64 hours. 6. What counts as a valid reason? Beyond your own illness or a doctor visit, many statutes let you use time to care for a family member, get preventive care, or handle safe time needs related to domestic violence or stalking. Check your state/city's permitted uses. For example, Colorado HF-A spells out qualifying reasons, and Rhode Island expressly includes safe leave. 7. Local versus state conflicts. If a local ordinance and state law both apply, employers generally must follow the standard most favorable to the employee. Minnesota's SST guidance makes that point explicitly for overlapping local rules. 8. Remote and multi-state work. If you work remotely inside a state with a sick leave law, you're often covered even if the company is elsewhere. New Mexico's guidance, for instance, covers remote workers in-state and explains jurisdiction for out-of-state employers. When you travel for work, coverage can become a case-by-case analysis. Document where you work and check the law of the place of work. The takeaway: once you identify where you work, the rest, accrual rate, cap, carryover, waiting period, and permitted uses, falls into place. Part 4. How to use your rights and what to do if you're denied. Here's a practical roadmap to use paid sick time and enforce your rights if you hit resistance. Step 1. Check your policy and the law. Grab your employee handbook or PTO policy and compare it to your local/state rules. If you're in California, New York, New Jersey, Oregon, Washington, Colorado, Minnesota, New Mexico, Illinois, or DC, you likely have statutory rights that set minimums your employer must meet. Keep links handy to the official state pages. Agencies like WAL&I, ORBOLI, NY, CADIR, COCDLE, ILDOL, MNDLI, and DC. Does. Publish plain English summaries. Step 2. Request leave the right way. Most laws allow reasonable notice for foreseeable appointments and same-day notice for sudden illness. Many jurisdictions limit what documentation your employer can demand for short absences. If your employer insists on rules that seem stricter than the law, flag the statute or agency FAQ and politely point it out. Example: Oregon's printable guide explains the basic rights and timing rules for use. Step 3. Track your accrual and pay. Laws usually require employers to show your sick time balance on a pay stub or regular statement and to pay sick time at your normal rate. If balances don't look right or your pay is short, take screenshots and email HR. In Washington, for example, the state outlines minimum accrual and carryover and enforces compliance. Chicago's ordinance likewise spells out accrual and coverage thresholds and is enforced by the Office of Labor Standards. Step 4. If denied, escalate. Start with HR in writing. If that fails, file a complaint with the state or city agency that enforces your law, e.g. WAL&I, paid sick leave, ORBOLI, NYDOL, CADIR, COCDLE, ILDOL, MNDLI, or DCDOES. If you're a federal contractor employee, the U.S. Department of Labor's Wage and Hour Division enforces EO 13,706 rights. Step 5. Watch for retaliation. It's illegal in many jurisdictions to punish you for using or asking about your earned sick time. If your hours are cut or you're disciplined shortly after you use sick leave, document the timing and contact the enforcement agency. Washington's L&I page includes an enforcement section, and New York's program explicitly addresses anti-retaliation. Bonus: local layers matter. Cities like Chicago and Seattle stack local rights on top of state rules. If you work in those cities, you may have extra protections. For example, Chicago now has 40 hours paid sick plus 40 hours paid leave for any reason per year. Seattle maintains long-standing PSST rights and aggressively enforces them. Are you eligible for paid sick leave? In the US, it depends on where you work and which laws apply. Federally, there's no general paid sick leave mandate, though FMLA provides unpaid job-protected leave, and federal contractor workers get paid sick leave under EO 13,706. Many states and cities now guarantee paid sick time with clear accrual rules, caps, carryover, and anti-retaliation protections. If you're unsure, check your state/city agency page, your employee handbook, and your pay stub for accruals. And don't hesitate to file a complaint if your employer isn't following the law. Want more step-by-step guides like this? Subscribe, drop your questions in the comments, and share this video with a coworker who needs to hear it. Your health and your paycheck both matter. Know your rights and use them.